Well, I think, Ray, there is considerable agreement on both sides in terms of both a clear-headed understanding of the threat and also great understanding and appreciation for the right of privacy. But where there's an essential difference, it seems to me, is how that right of privacy is to be protected in light of the seriousness of the threat. As I heard your side articulated, you were taking the position that you needed the standard type of approach that we've always applied in the context of criminal process, that we would use probable cause theories, that we would seek out a warrant, that we would have this all determined in a normal judicial process. Our point is that the nature of information has changed, and so my question for this is, and the nature of the threat has changed. Would your proposal, your perspective, prohibit the government from using a radiation detector to search for weapons-grade plutonium, driving around the streets of Washington, D.C., past homes and churches and synagogues and mosques and office buildings, effectively searching these facilities for telltale signs of a nuclear device?
The answer to your question is no. If you could construct such a device that would reveal the presence of only materials that would be legal for someone to possess, and you use that device in public places, I think there would be, in those circumstances, no expectation of privacy, no need to go to a court, no reason to obtain a warrant. But the example that you have provided for us this evening is almost at the exact opposite end of the spectrum from the type of mass public surveillance we experience today in this country. Because what was reported by the New York Times in December of 2005 and by USA Today in May 2006 was not a device that could detect plutonium, but the collection of the telephone records of U.S. citizens suspected of no crimes, turned over by the telephone companies to the National Security Agency without a legal basis and without judicial authority. Tens of millions of telephone records, your records, my records, the people who have joined us this evening, were provided to the government without any judicial review. That is the expectation of privacy that is under assault post 9/11, and that is the expectation of privacy I would argue we need to defend. So as for your example, of course, use such a device, no one is going to raise a privacy argument. But as to what is actually taking place in this country, there we have an expectation of privacy that our courts and the administration should respect.
You have 1 minute for rebuttal.
Well, I think that's a very helpful answer because it again finds a new basis for agreement between us, and that is there are circumstances that obviously you recognize where the government can proceed without proceeding through the very cumbersome process of a warrant and probable cause. Your concession that this device could be used without going to a court. I think your attempt, however, to draw a distinction between that device and the request to the telephone and telecommunications industry to provide not the content of conversations, but telephone numbers and the locations that were called and the frequency in the calls, so that a data matching exercise could basically follow a terrorist thread to identify where in fact the location of harm may come from. To have that necessarily encumbered by the criminal justice process is, I think, to lose sight of the principle that justified your first agreement with the hypothetical that we gave you.